Good morning, everyone. Going to start a presentation. Anybody want to join us? All the people hanging around chatting there? Please come and take a seat and join our presentation. Right, I'm going to talk about today digital business transactions. Okay. Now, first of all, I want to explain a little bit about the life of a lawyer. Okay, because that's what I'm a lawyer, obviously, and I'm here with Lleida.net, and I'm going to talk about. Sometimes as lawyers, we're required to act very swiftly with a new issue, and we need to be very swift in our actions, very swift in our legal assessments. Sometimes we have an emergency situation where we need to be on board quickly. We need to act quickly, and we need to put out a legal issue which is quite hot. And sometimes, I'm not saying that I need to be a superwoman, but sometimes we need to help companies, or our company, assess situations which are not an emergency situation, not something which has just come on board, but something which we need to bear in mind to help us move swiftly, to help us move through different areas of the law. So, I want to talk about emerging EU tech laws and the new standards in the EU. So, there's a Digital Act package, which is the Digital Services Act and the Digital Markets Act. Both are applicable across Europe. The Digital Services Act entered into force on the 16th of November this year, applicable from the 17th of February next year. And what is this act about? It relates to online intermediaries and a host of new obligations for these online intermediaries. It includes provisions on online content, transparency, user rights and protection. And what is very good about this act is it also provides safety mechanisms for businesses like ourselves. Businesses operating online will benefit from access to tools for flagging illegal content, which is very relevant in the age in which we are in now. So, the Digital Services Act applies to providers of digital intermediary services, where they play an active role. Please sit down, please make yourself comfortable. Where they play an active role in the giving of knowledge or the control of information. Where these services are offered to natural or legal persons. When I talk about legal persons, I'm talking about companies established in or located in the EU. So the type of digital intermediary services we're talking about are internet service providers, and there are many of you here today. Providers of cloud computing, also present today. If you're not sitting here, I don't know why. Internet access services, social media networks, app stores, online marketplaces, and online search engines. Obligations have different levels according to what type of service you offer. There are level obligations, more stringent obligations, and stricter rules for large online platforms and large online search engines, all present today. As with all acts, failure to comply hits where it hits and where it hurts the most, in the pocket. So there are fines of up to 6% of annual global turnover, and obviously that percentage lowers according to the type of breach. But serious breaches up to 6% of annual turnover. Of course, there are exceptions. Exceptions where the service provider does not control the giving of the information, where they're simply providing an access to that information. And also where they provide temporary immediate storage that is not applicable to the Digital Services Act. all service providers, intermediary service providers, have to have terms and conditions which are transparent and information on policies and procedures. If they are not established in the EU, it still applies if they're offering services to the EU. They must have an EU representative who can also be held liable for and they're not completing with the law. Okay, so it's not a role which is taken on easily. Hosting service providers must have notice and action mechanisms which need to be user-friendly. So I'm talking about language which we can all understand, not necessarily languages that are used by the lawyers. And they must process the notice and act swiftly when there's an infringement. Continuing. They must have the balance between complaints and freedom of speech. Okay, it's not we can't say prohibit everything, but there must be an equal balance between the two. And if those providers are allowing their users to contract with other traders, those traders must be able to be traced. They must have their contact information so that if any issues with the services contracted, the user is able to find that trader. Super important. Online advertising. You need to define the parameters and determine the types of represents and how to change those parameters. And in terms of consent, it's very different to GDPR. I'm going to talk about GDPR because GDPR, the General Data Protection Regulation, is always present. It's always in the background, and it's something we always need to bear in mind, whatever type of service we're offering. So there's a different view in terms of consent. It doesn't prevent profiling without consent, as does GDPR. And it's also able to have advertising in terms of minors, which is not possible in GDPR, according to the age of the child. Very large online platforms and very large search engines need to have effective and diligent identify systematic risks. They must look at those, they must balance those, okay? And they must supervise their activities. So why? Why do we have the Digital Services Act? For a safer and more open digital space, okay? We're not here to stifle business. We're here to encourage business to grow, okay? And how will it be enforced? It will be enforced by a digital services coordinator, which will be designated by member states. I don't know if this brings into mind any film to anybody? No? There's a famous film called Sister Act with Whoopi Goldberg, no? Where she is a nightclub singer, and she witnesses a crime and she has to go undercover as a nun, and she's singing as a nun. But anyway, I'm not talking about the film Sister Act, but I am talking about a Sister Act, which is the Digital Markets Act. Also entered into force in November last year, applicable from the 2nd of May this year. Registration by gatekeepers, and I will tell you what a gatekeeper is. Gatekeepers need to register by the 3rd of July this year. So this one is a little bit more on our tails. This one really needs to be taken into mind right now. So the Digital Market Act seeks to prevent large and influential digital companies from implementing practices which are considered to limit competition or otherwise be unfair. And they act as important gateway between business users and consumers. Okay, so we're talking about a business which has the ability to connect many businesses with many users via their services, which basically means that they have access to large amounts of data, and we're trying to control how they use that data. So it works in terms of increasing business rather than stifling it. So when we talk about gatekeepers, we're talking about online intermediate services. We're talking about online search engines. We're talking about online social network services. And we're talking about online video sharing platform services. We could all think of examples of that. We will look at that in a minute, but we can all think of examples. So, when we talk about gatekeepers, who are the ones who have to bear in mind the Digital Markets Act, there are two criteria, qualitative and quantitative. Qualitative, they must be a provider which has a significant impact on the internal market. They must operate a core platform which serves as an important gateway for businesses to reach end users. And they must have an entrenched and durable position in its operations, or the ability in the future to have that position. The quantitative criteria, which is the one, we're talking here about money. We're talking about big companies. We're talking about 6.5, at minimum, 6.5 billion euros in the last 3 financial years. We're talking about providers who have 45 million monthly active end users established or located in the EU, and more than 10,000 yearly active business users established in the EU. I mean, we're talking about a lot of companies that are here present today. Type of gatekeepers: Google, Meta, Twitter, Uber, Airbnb, Amazon, and maybe some of you here, okay? What obligations do they have? Data, advertising obligations, commercial relationship between their service providers and end users. Please sit down. You two gentlemen there, please sit down. Just a moment. And the last act I'm going to talk about is the artificial intelligence regulation. It's the first of its kind. It's a regulation, so it will be directly applicable to member states without the need of a national law. And its aim is to set out harmonized rules for AI systems in the EU. Okay, we all have our own concept of what artificial intelligence is. And the only thing I can say at this moment in time is that there is no universal definition of AI. And this regulation recognizes that. It recognizes the need for a future-proof definition. I mean, I don't think that's very realistic. I don't think we're going to have a future-proof definition because technology always moves a lot faster than the law. We all know that. So the AI regulation will be extraterritorial, so there's no need to be based in the EU. It will apply to companies who are place or put an AI system in the EU market, regardless of where they are established. Okay? So there's a lot of the big American companies that we have here present today. It will still apply to them if they're offering or placing these systems in the EU. And where, more important, the users are based in the EU. As with all laws, there are exceptions. Military purposes obviously don't come under this law, and public authorities in developing countries or international organizations using AI, international agreements also don't come under the umbrella of this act. As we saw before, if they're not based in the EU, it doesn't matter, okay? The important factor is whether there has an effect in the EU and where the users are based. If they're based in the EU, they need to have an EU representative. There are 4 types of AI recognized by the Act. Unacceptable risk, which is prohibitive. So that's manipulative AI. Social scoring by public authorities. And we're talking about where they give you or take away points based on your behavior in the country. Now, I'm not going to mention specific countries here because some of them are present, but we know that there are countries which operate AI social scoring. Okay, so we're trying to avoid that, except for cases such as law enforcement, but even that is limited in terms of how they can use that. There's also high risk AI, and they have special obligations in terms of how they manage that risk and in terms of having a database at European level for standalone high-risk AI. 2 more categories: limited risk, which has specific transparency requirements, and minimal risk, which has no specific transparency. But basically, if we're dealing with a chat box, we need to know we have a chat box. I mean, it's mostly evident to most of us most of the time because we can see the picture or we can see the moving image, and they always ask you, "Can we help you?" We know we're talking to a chatbot, but that's a minimum in case there are any startups that are thinking of doing this. At the European level, we will have the European Internet Artificial Intelligence Board, which will offer opinions on recommendations, comprised of national supervisory authorities, the European Data Protection Supervisor, because as I said, GDPR is always present. And we're talking about laws at a European level, and we're trying to balance the different laws. And the European Commission will be the chair. Sanctions, as before, we're talking about 6%, 4%, 2% of gross annual turnover. So we're seeing percentages which we also see in GDPR to have consistency across the laws. Member states are responsible for those sanctions. And in terms of damages and indemnification, the Act does not deal with that. So just briefly, how does it relate to GDPR? I've already mentioned briefly, but in terms of the UK, for those who are coming from the UK or doing business with the UK, GDPR was incorporated into the UK law before it left as a member state. After leaving as a member state, they retained aspects of GDPR but made their own GDP UK. And that deals with automated decisions, as does to the European level, and therefore it deals with artificial intelligence. And very quickly, finishing off, Lleida.net. Who are we? Where do we come from? What do we do? Right. We're a big player, a very big player. We have more than 17 offices across the world. We act on a global level. We're a global operator in telecommunications. We are IAS qualified, which means we can send digital communications around the world, digital communications which are legally valid, digital communications which enjoy the presumption of integrity, validity, and acceptable before the courts. Okay, the idea is that you don't need to go to court, but using our services, if you need to, or if you want to avoid to, we can send those communications to prove when they were sent, the time they were sent, the time they were open, all of that qualified at a European level. We are, for those who have never heard of us, we are on the stock exchange in New York. We are in the stock exchange in Madrid. And we are in the stock exchange in Paris. So we are big. We are seriously big. We are ISO qualified for information security management, and offices in 17 countries around the world. Here are our offices. As you can see, Lleida, name of the company. Madrid, Paris, Lima, Cape Town, Johannesburg, Tokyo. We're all over. Massive players. And we have patents around the world for our services, for certifying electronic messages, for certifying mobiles, for certifying electronic contracts. I mean, I put here 200 patents, but in reality, it's more like 220 patents around the world. 220 patents granted by 63 countries around the world for 3 business lines: e-notification, electronic signature, messaging solutions, data validation, and know your customer services. All at a European, recognized at a European level. And from my point of view as a lawyer, the important thing is that we can provide documentary evidence. Okay? This helps not only to avoid legal procedures, because we can prove that we send that message. We can prove the date, the time, the second. We can prove if it was received. We can prove if they opened it. Yeah? And it's a good point for conciliation before going to court, because as a lawyer, I always say the most important thing is try to avoid court, because at the end of the day, it's a financial risk, a reputational risk. So that evidence has telephone numbers, IP, emails, technical annex, timestamp, electronic signature. So that's it. That's the end of my presentation. I went over by 5 minutes, but I am a lawyer, so don't expect me to stick to the time frame. Any questions, please ask me. Please ask my colleagues. We're here. They're all friendly, look, attractive people here. They're all friendly, none of them bite. Please stay, ask questions, spend time with us. Thank you very much.